how often is the insanity defense successful? Have you ever wondered how often the insanity defense actually works in court? It turns out, this legal strategy is quite rare. In fact, it is used in less than 1% of all criminal cases in the United States. When defendants do choose to go this route, they usually find success only about 20 to 26% of the time. This means that roughly 1 in 4 or 5 attempts results in a verdict of not guilty by reason of insanity. To put that into perspective, only about 30 defendants each year successfully use the insanity defense in the entire country. So, why is the success rate so low? One reason is that the insanity defense is not just a medical diagnosis. It is a complex legal standard. Defendants must prove that they were unable to understand the nature or wrongfulness of their actions at the time of the crime. This often relies on legal criteria like the Monodon Rule, which focuses on whether the defendant could appreciate right from wrong. Another factor is the need for expert testimony from mental health professionals. Successful cases often involve defendants with serious mental illnesses, such as schizophrenia or bipolar disorder. In fact, around 90% of successful insanity pleas involve defendants who have prior mental health diagnoses. This shows that the defense is not just about claiming mental illness. It requires substantial evidence and documentation. Even when a defendant is found not guilty by reason of insanity, the outcome is not as simple as it may seem. These individuals are usually subject to mandatory psychiatric treatment and confinement. In many cases, they may end up in a mental health facility for longer than they would have served in prison for their crime. This reflects the legal system's focus on public safety and the need for treatment rather than just absolving responsibility. Additionally, the insanity defense is underused for a few reasons. Many public defenders may not have the resources or training to fully investigate and present this defense. Moreover, prosecutors and defense teams often agree on whether the insanity defense is appropriate before the trial, which can lead to fewer contested pleas. From a true crime and criminology perspective, the insanity defense remains a challenging and often misunderstood aspect of criminal law. Many people may think it is more commonly used than it actually is, largely due to how it is portrayed in the media. In reality, it is a narrowly applied legal tool that is reserved for a small number of cases involving severe mental illness and significant legal scrutiny.